Yes, Mr.
My Lords, in my submission, there are two ways of approaching this. There's a simple way or there's a complicated way. We've heard the complicated way, which involves a sort of Schrodinger's liability, which is both extinguished and not extinguished at the same time, where the words liability to pay damages have a different meaning in section 4.2 than they do in section 5.1a, although being exactly the same words, and where additional words have to be read into the statute. Or we can take the simple approach, which is to apply the recognised rules of statutory interpretation about which there is no dispute, look primarily to the words of the statute, which provide a simple exception to the general rule that Mr. Crozier's liability had indeed been discharged by his full and final settlement, but that his relatives, if they satisfied the three criteria set out in section 5, would have their own limited right, because it is a limited right, it's only in relation to what we call the Loss of Society Award. They have fulfilled all three of those criteria. Now, even if one wishes to go beyond the clear and unambiguous words, if one's going to look at the purpose and the context, the Holy Trinity, as it's been called, then the purpose of the legislation is simply to preserve the rights of relatives of those who die from mesothelioma. There is indeed debate in the Justice Committee report and in the policy memoranda about whether to expand that beyond mesothelioma sufferers. There isn't any discussion of restricting it to within a smaller class of those who have suffered and died from mesothelioma.
Well, it does identify the mischief, doesn't it, as a particular class of people who are those who are about to die, who have mesothelioma. Well,
at some points it does to the death. The imminence of death is a key feature, but I like Lord Burroughs' description of the headline policy, or headline mischief being that, but not in my submission restricted to that. It's restricted to those who died from mesothelioma. And it's very important to remember, I think it's something that has been overlooked at points in the appellant's argument, that we're not saying Section 5 is invoked by pleural plaques. We're saying it's invoked by mesothelioma. This is a mesothelioma victim. It's exactly the type of claim in my submission that the Act was aimed at. And this is all in the context of the law, generally, both at common law and in statute, being more favourable to mesothelioma victims, asbestos victims generally, but mesothelioma victims in particular, hence the Fairchild exemption, hence the compensation.
But we've been shown a number of statements which indicate that there was thought to be a particular dilemma faced by people suffering from mesothelioma.
Yes.
And that the policy of the provision was to address that, provide a solution to that dilemma.
Yes. And
so, I mean, it may be well be that the extent of the legislation went beyond the mischief, but you accept that it did?
I wouldn't go that far, except it might have done.
You say it's possible in your case.
It's possible.
It's possible that it did.
It's possible that it did, but so what? That's my short answer to it is, looking at the clear words of the statute, they apply in the present case, and there is no good reason for them not to. And this perhaps brings me on to the matters that I know your lordships were particularly keen to be addressed on, and the question of provisional damages, and why I say, although it's portrayed as being the simple solution, in my submission, all it does is delay the dilemma. And I say that Mr. Crozier faced that dilemma in any event, because he was advised that by accepting full and final settlement, that precluded any further claim by him. And it could be a substantial claim. It would be a substantial claim for mesothelioma. But he would also have been advised, he was advised, and I'll come to this in slightly more detail, that at least his relatives would still have claims. That was the advice that he was given. That was the advice that was given as standard by those instructing me, who are probably the biggest providers of legal services to asbestos victims in Scotland. Between Thompson's and Digby Brown, I think about 90% of asbestos cases are dealt with by those two firms. And your lordships may...
Well, we can't construe the legislation by reference to particular advice that was or wasn't given to claimants, can we?
Well, I think it's
Well, perhaps in fairness, I did ask you to tell us how how these things worked in practice.
Yes. This was not a subject I'd anticipated addressing the court, and that's why your lordships may have seen a letter which hadn't been put before the court before now, because wasn't entirely convinced it was particularly helpful, but I think it might be in this context to explain why provisional damages are not the be-all and end-all, and how provisional damages work in practice.
Is the problem that provisional damages for pleural plaques is going to be quite small?
Yes.
So that, assuming you haven't got mesothelioma then, but get it a year later, you're going to be back in the same dilemma so far as the substantial damages are concerned.
Indeed, my lord, yes. The provisional damages will preserve some of the rights. I'm sorry, my lord. I think your lordships wanted to be addressed in relation to, specifically to paragraphs 25 and 26. Now, my learned friend took exception to paragraph 25, but I confess I'm still not quite clear which of those sentences he would say is wrong. It's self-evident that had Mr. Crozier taken provisional damages, he would have been in a better position than turned out to be the case, because he would still have had his own claim.
Right. I think it was accepted when put to Mr. Mackenzie, he accepted that on any view the defendant got a benefit from settling the claim at the early stage, because any loss of earnings claim was, if not altogether avoided, then massively reduced.
And your lordship made that very important point at 11:33 this morning, and followed it up with a very reasonable proposition that in those situations, why would it be unreasonable for the insurance company still have to pay out the relatives' claims? They've having taken a substantial benefit. Why would it be unreasonable and absurd or anomalous, or all the other words that were used to describe this position? And of course it is an anomaly, but again, as your lordship pointed out, it's a deliberate anomaly, and it is unprincipled because it's driven by policy, not principle. But it's there to preserve the rights of relatives of people who died of mesothelioma, which is the pursuers in this case. And all provisional damages would have done would have been to delay matters, so that in the event that mesothelioma was diagnosed, and just as an aside, when we've been looking at the wording, it's tended to be along the lines of whether the pursuer was suffering from mesothelioma at the time. Presumably the real test would have been whether he was diagnosed with mesothelioma at the time. It may well be that he was suffering from mesothelioma but didn't know that's what it was. And that's an illustration of why the courts are rightly reluctant to get involved in judicial legislation, because these things require careful thought, proper drafting by parliamentary draftsmen, consultations and all the rest of it. So when you start adding in words on the hoof, we are liable to run into difficulties like that. So that's my point in paragraph 26, that it would simply have delayed the dilemma. But there still was a dilemma in any event, even just at the risk of mesothelioma, except we don't have the imminence of death at that stage. But provisional damages would have delayed it simply until we did get to that. Now, Lords, this court essentially made all of the important points I wished to make this morning, and I'm not going to repeat them in a less elegant way than was done by your lordships this morning. I am, of course, happy to answer any questions in relation to the assessment of damages and provisional damages. And the slight oddity that I think none of us had really thought of before about the description of the award as being one for salatium. It does obviously, as we can see from the cases, incorporate elements of financial losses, loss of earnings, loss of services, etc. And it may simply be laxness on the part of practitioners in describing it as a salatium award, or it may be that the concept of salatium is broader, I think, than general damages in England. I have an English law degree.
You're talking now, are you, about the award made at the stage when the person is suffering pleural plaques, but including an element for the risk of going on to suffer mesothelioma?
Yes. So that
you're saying it incorporates, whatever it's called, it incorporates all aspects of the risk.
Indeed. It's a lump sum. It may well be poor expression, but it does incorporate all of those elements. And one can see that from looking at Harris. I don't know if there are any other additional matters.
So you say, in terms of the dilemma, it may not be the precise dilemma that somebody who is suffering from mesothelioma and knows that they're suffering from mesothelioma, but in any event, there is a form of dilemma.
Yep.
In any event.
Absolutely, my lord. Yes.
If one broadens the concept like that, then there's a form of dilemma in any, I mean, if you go on to develop lung cancer or something else, it's not particular to mesothelioma, because there's always the prospect of...
That's true, but Section 5 wouldn't operate in that.
But I think what my lord's suggesting is that the prospect that under Scottish law the relatives might do a little bit better than you would isn't limited to mesothelioma.
No, that's correct.
Thank you. Well, thank you very much, Mr. Milligan.
I'm obliged.
Mr. Mackenzie, any matters arising?
Yes, my lord, only one. And that is, my learned friend, with something of a metaphorical shrug, said that it's possible that there was an innovation or an extension of the mischief. He said, so what to that? The policy was carefully considered. The policy of the Parliament, in terms of the separation of powers, is not to be that lightly dismissed by a shrug, by a so what. There were, as we've seen, policy memoranda and financial memoranda that looked at the implications of the legislation. And my learned friend has accepted there is an ambiguity in the terms, and he's also asking for an ambiguity in the mischief. In my submission, what precisely my learned friend is asking this court to do is to undertake an act of judicial legislation without being properly informed on the matter. The mischief is as described, the policy is as described, and the wording, even if there were an ambiguity, is reinforced by the wording of the government minister, and it should not be innovated upon. unless I can assist my Lords further.
Thank you, Mr. Mackenzie. Well, we're grateful to counsel for your submissions. We'll take care now to consider them, and we'll let you have our judgment in due course. The court will adjourn.